All right, so what we've got is legal updates. We do this from time to time, and it tends to be a pretty popular topic. So we try to keep it fresh, usually hitting regs and whatnot that are active, as well as case law we get from word searches and that kind of stuff. In terms of the stuff that we're going to be talking about here, the three big regulatory things that are coming up from a compliance deadline is the OSHA reporting online. We've been getting, obviously, electronic logging devices, which isn't directly related to school bus, but we've been getting a lot of questions on it for the overlap with either charters or school buses used for activity runs that may fall into the charter category. And then the FLSA permanent injunction as it relates to overtime rules and things like that. After that, we'll talk about the 5 or 6 cases. So let me get on to the OSHA reporting. This was regulation that had an original compliance deadline in July of 2017, and that was actually pushed back to December 1, which is now shortly upon us. So it's a little wonky in that they're talking about compliance for reporting your your 2016 OSHA incident information, but that is what it applies to, and I'm sure that there'll be a little catch-up process in there as the enforcement date is upon us. In terms of who needs to report, those that have 250 or more employees, or if you've got 20 to 49 employees in industries with high rates of injuries and illnesses. And school bus operations is one of those that's identified on the NAIC insurance codes as a high-risk occupation. Then you've been required to keep a paper log, and if OSHA were ever to come to your location, or if you had an incident, they would probably want to see those logs to make sure that you were doing what is expected. Insurance companies generally like to see those as well, too. When they come out, as many of you know, I used to be a vice president at Harleysville, was in charge of risk management. So when we would go out to evaluate the insurability of a school bus contractor, our risk engineers would ask to see your OSHA reporting forms. And ideally, you would pull them out and look at them, and the insurance guy would be impressed and would tell the underwriter. But if you say, I don't have them, that's not a great answer. Or if you say, I don't know what you're talking about, that's not a great answer. And that all goes back to whether insurance companies find you an attractive risk and give you a good price or not. So what does this mean coming in December with the new OSHA electronic reporting rule? What it really means is that those paper forms now have to be done online. It's not as complicated as it seems. The original deadline was in July, and they've moved that deadline to December 1. What you can do is go online, and you actually open up an account, we'll say. You establish on the injury tracking application at OSHA, and there's a website down at the bottom there. And if you need that after this presentation, feel free to just give us a call or shoot us an email, and we can reply with that if you haven't written it down. But what this basically does is it sets your business up as an employer that is required to report, and you have a couple of options. You can literally go on and type the information manually. Joe was injured when he tripped on a school bus step, and there you go. Here's the date. Here's the info. If you have a little more traffic than that injury-wise, you can actually upload an Excel spreadsheet into this injury tracking application with OSHA. So let's say you've been keeping this information on an Excel spreadsheet. The application does actually allow you to upload Excel spreadsheets in a CSV file format, and that's one of your options. The third option is that there are actual applications where people take care of their OSHA reporting in-house. And some of those applications are designed to communicate directly with the OSHA injury tracking application. Again, I think you've got to have a significant amount of workers' comp traffic to make something like that worthwhile. Most of the contractors that we deal with are, fortunately, not having that level of injury tracking. So I would think that simply going onto the OSHA site, opening up your entity record, and then if you have a work comp injury, making sure it's reported there online is probably sufficient for 95% of the people that we deal with. You know, if you run into difficulties with that, Sandy in my office has helped a number of people set that up. So feel free to give us a call and move forward in that regard. That's pretty much it for OSHA. Again, hasn't generated a whole lot of activity, but I think that contractors are wise to be aware of it, to comply with it. Even if you have minimal work, at some point, your insurance company's risk evaluator is going to be out either at renewal time or whenever, and they'll be impressed that you are aware and compliant. I'm going to move on to FMCSA and electronic logging devices. And I'll stop after this and take a couple of questions and whatnot. And Maggie, like I said, if you have any questions out there that are already submitted, I can certainly take those. Are you receiving anything in text?
Yes, I received a sort of general question. Will this PowerPoint be available to print afterwards?
Yes, we can certainly make it available. We have everybody's email. And Maggie, what's the easiest way for us to make that available to them? We could put it on the PSBA website?
We do that.
Okay. Yeah. All right, then it'll be available on the PSBA website, and Maggie or Mike, if you have any trouble finding it, can direct you right to it. Okay. Excellent. And if there's any other questions, Maggie, let me know. Great. FMCSA and electronic logging devices. The electronic log rule was finalized, and starting December 18th, if you were previously required to maintain a paper log, you will be required to maintain that log electronically with a device that's installed on your vehicle. Now, the question of, am I required to have a paper log, as you know, is dependent upon the hours of service, dependent upon your use of the vehicle. Generally speaking, home to school, school to home are exempted from the requirement. At the federal level, it's 49 CFR 390.3 and 390.5. Those two rules say school bus, home to school, school to home is exempted from the RODS log, record of on-duty service log requirement. Now, there are exceptions and carve-outs, obviously. If you are on runs and actually in service for more than 12 hours, well, then you would still be required to log your miles and log your time. And if you are outside of your short haul exception, which is a 100-mile radius, you could be required to have a paper log as well. You'll see on the screen there that there's a few carve-outs, and I think the one that is most useful to be aware of for school bus contractors is that exception down here that talks about 8 days in a 30-day period. The new electronic requirement does have an exception at the federal level that says if you are required to maintain a paper log under existing law, but you're not required to do it more than 8 times in a rolling 30-day period, then your paper log is sufficient. You don't have to have an electronic device. But if you are going to be required under existing law to keep a paper log more than 8 times in that time period, then you do have to comply with the ELD requirement. Now, there's a couple of ways that contractors can comply with that. You should probably keep track of which drivers are driving and which ones are going to need to have a paper log. If they are, close to their 8 days and 30 time frame, ideally you have another driver that can take that run. But I understand not everybody is, that thick with drivers. It might be that you're the one that does the, those runs, and it's got to be you, and you're over your time. So we've worked with contractors in different compliance scenarios. Some of them have decided to put an ELD on 1 or 2 of their buses. And if they've got to, do a run where they would be required to log and they would be required to be electronic, then they have a bus that complies with that. We have others that are not investing in the logs because the amount of time that they have to drive and where they would be required to do a log is minimal. And so they're just simply keeping a tick count. How many logs did I have to do? How long has it been? And if they're compliant, they go. And if they're not, they have somebody else take that run. one of your other options there you see is that if the vehicle is manufactured before the year 2000, you're not required to have an electronic log. Not a lot of those old vehicles out there, or if you have them, they're probably, you know, in the back for spares. And if you've got to do a long run, you probably don't want to take that old vehicle anyway. But, you know, be aware that that's there. Again, not a lot of 1999 vehicles in daily service, but that's also a way. So situational compliance, interstate, meaning crossing state lines, must comply. State-specific compliance. Some states are wrangling with the oncoming deadline in different ways. For example, in Florida, the legislature has requested a straight-up delay. Say, we're not ready yet, give us another, whatever, 6 months. I don't recall the exact status of that, but I do recall that that was something that we saw out there. In Pennsylvania, I know that Mike has talked with the Pennsylvania State Police and PennDOT, as have I, and there are some anomalies in state law adopting those federal exemptions that I talked about, the section 390.3 and 390.5. But those anomalies have been there for many, many years, as long as 2010, as I recall. Mm-hmm. So while we've dialogued with both PennDOT and Pennsylvania State Police, and they are aware of those anomalies, we don't have any reason to believe the world is going to change in a big way in Pennsylvania on December 18th. But I share with everybody that if you do see issues on this point, you know, somebody in an enforcement action, you know, says, hey, you've got to have an electronic log on this bus, and it's not something that's within this 8-day, 30-day period exemption, I really suggest that you either give me a call or give Mike Burke a call and just chat up the situation, because we're monitoring state activity on exactly that point. Yep. We don't believe any heroics necessarily is required, but if we find that you know, state troopers are either citing school buses or indicating that they're going to cite school buses, there are actions that the PSBA can take, requesting waivers of certain sections of Pennsylvania state law, things like that. So again, we're looking for you to be our eyes and ears on the street. If you see issues, get issues, have questions, you know, by all means, Mike or I can help you out with that. And we're prepared to take whatever action is necessary. At this point, we don't really believe that any heroics or filings or things like that is appropriate at this time. So that is the logging. In terms of one other item that we're going to talk about, it's the Fair Labor Standards Act overtime rule. A couple of people have asked about that, so we'll talk about that as well. If everyone recalls, about this time last year was when the Obama era rule on overtime was about to go into effect. The rule was going to change the salary level test for who has to be paid overtime from a threshold of about $23,000 to a threshold of about $43,000, somewhere around there. It was going to about double it. And that whole issue was, if an employee was under that threshold, they were clearly entitled to overtime. If they were over that threshold, then they were not necessarily clearly entitled to overtime. So it had the potential to increase the number of people that had to be paid overtime. A Texas court had decided an injunction filing and actually stopped the enforcement of that back in December of 16. Over the summer, August 31 exactly, of 2017, that same district judge concluded that the rule was invalid and the threshold of $23,000 was restored. At the same time, the Trump Department of Justice, who had been still in charge of the pending appeal, which was started under the Obama era, decided that they would no longer pursue the appeal. The end result of all of that being that the $23,000 threshold is in place. The reason I mention it is for two reasons. the $23,000 threshold is in place, but be aware that there is still a need to be mindful of who should and should not get overtime. There's the salary level test, which is what this is all about. And then there's the standards and duties test. And even if someone is over a salary threshold, a lot of times the enforcement arm, that is the Department of Labor, is going to look at the duties that person does. And if they are administrative in nature, if they're not at some level, I'll say, supervisory or something of that sort, then it may be that they are likely going to be required to be paid overtime. So basically, the administration component of that, if the person that is doing the work, the administrative person, is working in an office environment, if their work relates to the management of the company, keeping records, bookkeeping, those sorts of things, if they have to exercise independent judgment, and if the work is considered significant work, they're not simply cleaning a bus, they're actually processing payroll, they're paying bills, they are dispatching, they are doing significant work that requires independent judgment that relates to the management of your organization. That is somebody that would be within an exemption, and you wouldn't necessarily be required to pay them overtime. But you've got to look at your staff. You might have somebody that works in they're side by side, and this is your A person, and they're the one that you rely on and you trust their judgment. And the B person is their helper. Well, their helper doesn't have that same level of authority and trust and capability, probably. So it may be that you've got to pay the helper overtime, but not the first person. Thoughts on that, Mike? Or
no, it's just something you have to be careful of.
Yep. So that overtime rule is out there. That's the stuff that's been kind of active so far. And my thought was that we would go from here onto the question of the red dyed fuel and activity runs. Before I do that, though, let me open up the audio, or have Maggie open up the audio, and see if there's any questions at this point.
Maggie, are you able to unmute?
Yep, I'm unmuting now.
Great.
All right, everyone should be unmuted.
Okay, it sounds like we have open mic night. So anybody have any questions before we move on to the next section? We've covered a lot. Any questions from anybody?
Okay, well then what I'll do is I'll move on to the red fuel and those issues there. Recently there was an article in the Pennsylvania School Bus Association newsletter, and it was
Rich,
an article.
We just got a question come through.
Okay, excellent. What is that?
So if a mechanic works over 40 hours a week, income being more than $23K per year, is overtime needed?
I would expect that it's going to rely on the duties test more so than the salary threshold test. In other words, the mere fact that they're over that $23,000 threshold is a kind of a first cut of evaluation. But I think that if the Department of Labor was looking at compliance, they would look at this second step, which is the standards and duties test. And they would say, well, is this your lead mechanic, or is this the helper that replaces light bulbs when they burn out? If it's your lead mechanic, I think it's fair to say that your lead mechanic is exercising independent judgment. Do these brakes need to be repaired, replaced, or not? And it's significant work because it's important. And it relates to the management of the company. But if your lead mechanic then says to Joe, the junior mechanic, hey, Joe, replace these brakes, Joe isn't in a position to say, well, I don't think they need to be replaced. I'm going to let them go. He's supposed to do what the senior mechanic tells him. So hopefully that answers the question. If you'd like more on that, I can certainly explain it here. And if you'd like to talk in a little bit more detail just about your situation, remember under the Business Council program, you can call us pretty much any time, and we can have discussions like this about your particular situation, and there's no additional charge to you. That's part of your membership benefits. So hopefully that answers it. If you need more, type a note there, and Maggie will let me know. Any other questions out there, Maggie?
Nope, that's it.
All right, great. Then I'm going to go on to the red dyed fuel, and I give Fred Bennett, our current president, credit for looking critically at the article. And he's a guy that I like to debate school bus and law topics with. It's good fun. But in any case, he took a look at the article that appeared most recently about the use of red dyed fuel. And as I mentioned, this is something that came from a lot of questions. And the questions usually fell into this category. Can I use red fuel in my school bus? And people are thinking that there's a law that says, yes, you can use red fuel in your school bus. Well, the reality is that it's not as clear as that. Generally speaking, and this is what the article talks about, the red fuel rules and laws that are out there is a creation of the EPA and the IRS. Those two organizations got together, recognized that there were certain circumstances where red fuel, where fuel was not taxable, and that they agreed to dye it red so that it could be easily identified is that red fuel would only be used in off-road applications. A lot of times people call red fuel off-road fuel. So for farm equipment and construction equipment and things like that, the use of red fuel is appropriate. There are also carve-outs for school bus use within the IRS and the EPA codes, and they usually have a definition similar to what you see here in the article. That is, no fuel tax shall be imposed in the sale of fuel for use by an automobile bus while engaged in transportation of students, blah, 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 blah. I'm highlighting it on the screen there for you. And if you follow the breadcrumbs in the code, they will give you a definition of what is an automobile bus and what does it mean to be engaged in the transportation of students. And the interpretation as it relates to the taxation of fuel is pretty broad. It's not clear, but I think that it reasonably includes activity runs and things of that sort, assuming that they still have some relation to the school. If you're driving the Boy Scouts in the summer to the amusement park, I don't think that you'd be able to necessarily say that's a school purpose. But if you're driving the football team to the Friday night game, they're school students, they're going from one school to another school, and I think that under the rules as they apply regarding taxation, that you would reasonably be within the school bus use, meaning that you are not required to pay taxes on that fuel. Now, the reason that we hedge is in talking with some contractors. I have a contractor that said, well, at my school, all sports trips are paid for from the funds raised by the Parents Association. So right there, you have basically a charter. Yeah, yes, they're school students, but they're paid for by private citizens with funds raised by private citizens. So if you have a tax auditor in your office and they connect those dots, are they going to say that that is an activity run within the definition of the transportation of school students? Maybe, maybe not. I would try to convince them for you, and whether I'd be able to win, remains to be seen. But you can convince them as well. The point that I'm making is that the activity run arena is pretty variable. In its purest sense, it's the sports trips. and the school pays for it. But there's anomalies, and if you fall into one of those anomalies, you should probably be aware of it. And the risk really is what the article talks about mostly, because as you can see, you know, the question, can I use red fuel in my school bus? Yes, if you're transporting school students for school purposes, as defined by the laws. That question then becomes, well, does this scenario fit? Does this scenario fit? Does this scenario fit? I think the typical one will. But again, the situation with red fuel is that there's no hiding from it, if you know what I mean. If you've got red fuel in your tank, you got red fuel in your tank. And if you are pulled over and an enforcement agent, dips the tank, it's red. And ideally, they are of a mindset that this trip that you're taking is completely within the school to home, home to school exception. Will they interpret differently? It could happen, because the law is not really clear. I don't think that it would, but what I guarantee you're fine putting red fuel in the bus. Well, there's a risk, and that risk, as you can see on the screen, is this. Okay, there's penalties for running red fuel, and you can see that the penalties escalate if, and that's down here, the civil penalty amount may be multiplied if a violator has been cited more than once. So if you've never been cited for red fuel in your tank, and you feel comfortable that your factual scenario of your activity runs is pretty clearly within home to school, school to home, these are school students. It's not one of those weird situations where the school boosters pay for it, the parents pay for it. Then, I think that running red fuel on an activity run is a pretty safe risk. And at the, what you're risking is somebody dips the tank and they give you a fine like this. And that doesn't mean you have to pay that fine. You might fight that fine, and I would be glad to help you with that. But at the worst case scenario, that's the fine. Probably less than you would have paid in taxes. So there's that. However, if you've gotten the fine, and let's say you fought it, or you didn't want to fight it, you just paid it, well, then your risk of a second issue is a little higher. Now, I don't know of anyone that's in that, any school bus operator currently that's in that second scenario. I know of various transportation providers, usually trucking providers, that may or may not get jammed up with this one way or another. I know of various contractors that have dealt with this in various ways. Some of them simply pay the tax and ask for a credit on their taxes. That's one way to do it. Some of them run the red fuel and they just accept that risk. Some of them run the red fuel, but they've got a couple of vehicles that don't have red fuel. So how you deal with it is really going to be determined by your factual situation and the specifics of your environment. It may be that you don't have enough buses to have a yellow bus and other red buses. It might be that you don't have two tanks, you only have one tank. And there's a lot of variations. So these articles that I write are 750 words. And I can't address everything in 750 words, but we can certainly get the general stuff out there, and if there's other questions that come up, we address them case by case. So I'm not sure if Fred Bennett's on the line, but if he is, hopefully I did our debate justice. And if you see him, just tell him that we had this chat, and I'm sure he'll tell you what he thinks about red fuel and activity trips too. Maggie, do we have any questions on text online?
We do not.
Okay, great. Well, I think I'm going to kind of move on from there. We've got a couple few cases that we pulled, and I've got them kind of lined up into categories. We, from time to time, run searches on Westlaw, the legal research database, and we look for cases that relate to school bus and students and the work that all you guys do. The cases come from various parts of the country, but the one thing that I find is that school bus is a special niche, and it's not unusual that a court will look pretty broadly, meaning at other states, for direction and guidance when they're faced with issues related to school bus. So some of the cases that we talk about, while they may not be Pennsylvania cases, they're still relevant because I find that courts will go to these cases because they're factually related to what you do. So I've got about 5 or 6 cases, and we'll run through those real quick.
Do you want to bring them up on the screen?
No, I don't actually have them on the screen.
Okay.
I don't have them on the screen. No.
I just got another question.
Oh, all right, what's that?
So, does transporting college students to and from the college count as a school?
That's an excellent question. And I'll tell you, I would candidly have to probably look at case law. And in fact, I'm going to write that one down. Is transport of college students within the school to home, home to school? And this is just off the top of my head. This is not having looked at statutes or cases or anything of that sort. All of the statutes, actually the statutes that I'm recalling, I won't say all of them, the statutes I'm recalling usually talk about students in the K through 12, secondary, pre-secondary, that kind of thing. You read a lot of legislation, Mike.
And most of it, usually basic ed, K to 12, pre-K to 12 is kept separate. So I don't know. This is
and they usually do because they are creations of usually the Department of Education. So the Department of Education works with the Department of Transportation, and between the two of them, you put their rules together to say, here's what we need to comply with. Now, the Department of Education, I would assume, and normally is, that K through 12 sort of thing.
Well, you have a higher ed element of it too, but most of what we deal with is K-12.
Yeah.
So you'd have to do a little bit of
research. You know what I'm going to do is I'm going to table it, and I think I'm going to, because I was planning to put out something about red fuel as a kind of a follow-up.
Mm-hmm.
So in that follow-up are the transport of college students within the exception. Whoever's got that question out there, after this, my email's up on the screen there. It's rckelly@rckelly.com. I'd love to just hear from you a little bit about your factual situation, because I can kind of work that into the evaluation that we do. So sorry, that was like typical attorney answer.
Good question, though.
Very good question. And look for something in the PSBA newsletter, and/or give me a call, and we'll talk about your situation directly. Any other queries out there, Maggie?
Yes, we have one more.
Okay.
So a rule of thumb that is used for one contractor, that if a trip needs to be a BA or bus license trip for a college or university trip or any other non-school group, clear tax fuel should be used.
Okay.
So that's more of a statement than a question.
No, I love it, actually.
Yeah.
That's really good. And that's kind of consistent with what Mike and I were saying from a kind of a soft feel, which is, K through 12 is pretty clear.
Yep.
Beyond that, it would be a stretch. And,
I'm not sure the intent was ever to cover.
Right, college transport and that sort of stuff. So you know what, you're better off keeping your fuel clear yellow. And if you feel brave enough to claim that credit on your taxes, then that's probably a safer way to go, but nobody likes to tangle with the IRS. Good questions and good input. Very much appreciated, everybody. So the screen that I've got up there, like I said, I don't have these specific cases, but I'm going to run through them. And the reason I don't necessarily throw the cases up there is, I'd be happy to send these cases out to anyone, but I think it's the concepts that we find as themes and theories. So the first one is a New York case that relates to seat belts. And as you know, or maybe don't know, New York has a rule that says seat belts must be installed in buses. So, the buses come out, they're installed, but the New York law does not require that seat belts have to be used. And in this particular case, there was an accident. A student was injured, and the parent of the student sued, saying, well, you didn't have my seat belted in. I know. Mike's rolling his eyes. I feel your pain. I feel your pain. So the beauty part of this, though, is the school. This is Chan Cheeseboro versus Ritchie Bus Service up in New York. The bus service defended, and the court agreed that the statute requires only that they be present in the bus, and that there's no requirement in the statute that a driver or contractor or anybody has to go and make sure these kids are buckled up. So, yay, score one for the good guys.
Absolutely.
You know, it was a good, clear interpretation of the law, and I was happy to see a contractor conclude that well. Now, you know, we don't have a seatbelt law currently in Pennsylvania. Is there anything kicking, Mike?
There is legislation introduced, but none, all the, you know, I'll knock wood when I say this, all we are hearing is that there has been no push to move any of that legislation along. So,
yep. And we, you know, follow this on a countrywide basis as well, too. And at any given time, it seems like you have, you know, half a dozen or so states that are toying with it. And you've probably got maybe 6 or 8 states that actually have seatbelt laws, but most of them require them in newly sold buses. And I believe also most of them don't require the use of the seatbelt, only require the presence of the seatbelt.
Right.
So that's the environment for that right now.
In some states, the law has been passed that says it can, you know, it can require seatbelts, but until such time as funding has been appropriated by the state to cover the cost of including the seatbelts or retrofitting, the law sits out there. And a lot of times it's introduced in Pennsylvania. Some legislators introduced it as a promise to a constituent.
Yes.
But we ask the question every so often of those sponsors, just to make sure that there's nothing planned. Yep. So we keep on it. If we feel like it's gearing up, we then get you know, the members notified, and we start to make a push.
Yep, that's good. So Mike's minding the store for you, and we'll let you know if there's any activity on that. The second case that I have is actually a Pennsylvania case, and it's Upper Merion Area School District versus the Teamsters Local, and this relates to termination and fitness for duty issues. So this case that I'm talking about was decided in June of 2017. The case previously was also a June of 2017 case. But so this is a June 2017 case in our local area here, Upper Merion. And the issue here was that a driver was pulled for a random drug test. It's your day, you know, go to the doctor, pee in the cup, do what you got to do. So the driver goes, and the test comes back positive. So, of course, you know, there's a little bit of excitement back and forth, you know, did you take drugs and things of that sort. And this particular, and it wasn't really, a contractor, it was the Teamsters, it was a union, had language that did direct that you could be fired for a violation of the drug and alcohol test. But it was not absolute. It was not, you will be fired. It was, you may be, you could be. It was soft language. So the driver basically appealed the decision, saying that I shouldn't be terminated because the scenario was that my son had some medicine. It resulted in him losing weight, and I wanted to lose weight. So I took my son's medicine because I wanted to lose weight. So the factual scenario was that was her defense. Her defense was, I didn't know. I didn't know that this drug would have that impact on me. And I didn't know it was not legal, blah, 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 blah. Well, in this scenario, I guess ignorance was a defense because the court directed that she should be reinstated.
Wow.
And the reason they said she should be reinstated is because the driver was not a recreational drug user. This is not a druggie driving a school bus. This is a mom who is otherwise responsible and has an otherwise clean record that made a bad choice. And they dovetailed that with the school bus operator's actual employment manual language that said that was soft. It didn't say you're going to be fired if you test hot. It said basically that we're going to consider the circumstances, which they were required to do. So I'm sure, and again, I don't know the players specifically, but I can imagine it's a hot drug test. They probably had to tell the school probably said that driver's out, as they always say. And, you know, the operator probably did what the school required, even though their manual was a little softer. I think the real takeaway there is be aware of what your policies say. And if your policies provide for discretion, then make sure that you exercise discretion. Document the circumstances and the facts, and be sure that you have a policy in place, and that your activity upon finding a driver that tested positive is consistent with your policy. Again, if you need help with that, or you'd like some feedback, is my policy right or should it be different? We're certainly available to help you out with that. Grace is dynamite on reviewing those policies and that kind of stuff. That was a June 2017 case. I've got a case next from Supreme Court of Louisiana, and this one relates to drivers and routes, and that is those route and I always mix and match these two. This is one where the driver was unhappy with the route that they were reassigned to. That happens, right? Mm-hmm. Sure does. So what happens is, the spins and turns of routes, they decide that this driver, instead of driving route A that they've always driven, now has to drive this other route over here. And it makes sense for lots of business reasons. It's either, maybe where they are geographically, how the route's run, but it was not an evil, I'm going to do wrong to this employee. It was a business person being a business person saying, this makes sense. Unfortunately, the driver didn't agree that it made sense. They wanted their old route back, and they pointed to employment manual and company policies that took the driver's seniority into account in the assignment of routes. And this particular driver had seniority. They had been there a long, long time, and under the written policies that were in place, the operator of the school bus had pretty much had promised to consider seniority in making route assignments. So the reason that this one then went in favor of the driver, who not only got reinstatement to the route that they wanted, but also got $75,000 worth of damages for intentional infliction of emotional distress. Now, I don't like that part of the result at all, to be honest with you. I think that, okay, they had a policy that considered seniority. The evidence indicated that the operator didn't follow their policy. So, okay, I get that. They should be made to follow their policy. That's fair. Right. But $75,000 worth of angst, I don't know that I necessarily see that coming from having to drive a different route. Now, I guess it depends on the route. If you had the good kids on your old route and you got the bad kids now, that might be $75,000 worth of angst. But I think, again, the takeaway there is have policies, follow your policies. And chances are, if they had a memo that said, we've considered this driver's seniority, however, the business considerations of mileage, timing, convenience, equipment, whatever, trumps that seniority policy, I think they would have been okay. Yeah. But the reality is they basically said, nope, we assigned this route. It makes sense to us. And, well, what about seniority? What about it? So you get the idea. Next case I've got, and that was one from May of 2017. This next one is a little older, but it was really good. It was November of 2016, so it was about a year ago. And this one comes out of Florida. What I like about this is it really punctuates the need for drivers to not deviate from the routes that are set out. In this particular factual situation, it's called Davis versus Baez. A driver had a route where the school student was waiting on the left side of the road. So they would come to the stop, ideally, turn on the lights, put out the cross arm, and the student would cross in front of the bus and then get on the bus. Well, the driver told the students, look, just wait on the right side, okay? Wait on the right side of the road because that's where I'm picking you up. So the students did that. One morning, before the bus got there, they're crossing the road, they get hit by a car. Yeah.
Saw this coming.
Yep, exactly. And what happens then is they sue the operator and they sue also the driver personally. And the defense was that, well, this was really outside of the scope of the authority given to the school bus driver. The school bus driver is not really authorized to change the routes, and they're not authorized to make those decisions. So the court actually found that there was personal negligence on the part of the driver. Now, I don't say that to scare drivers. Really, I think that this is a product of municipal immunity. It was a school bus operated by a school district, and the districts were immune from tort liability. So the attorney and the courts were looking for some place to compensate for the injuries of the child. And they said, well, okay, if tort immunity applies to the school, who else is responsible? Well, okay, driver, you're responsible. Now, didn't get deep enough into the weeds to know if the coverage for the contractor or coverage, liability coverage, where it would come from. But I think the real takeaway here is that there is peril in a school bus driver taking routes into their own hands. You know, right, exactly. You know, don't wait at this driveway. You guys are, your stops are within sight of each other. You go to there, you know.
I'm in the process of getting my CDL and going through class. This is one of those things they emphasize. You as a driver have no right to do this.
Yep. No, that's absolutely right. So it's it was just a case that kind of tells us what we already know, but in a pretty strong way. If a driver has a concern about a route, they should really take that back to you as the operator and then back to the school district. And here's the other part of that too. Ultimately, it's the school board that has the authority to make those changes. So it might even be something that, okay, this, you know, that might need to go to a school board or might get their approval. But I think, you know, certainly taking it back to the school to say a change needs to be made here and not taking it into their own hands. Okay, here's another one actually. This is from Washington, and this is from, let me see, March of 2017. And this one involves student supervision. And I love this case too, which is Bell versus Northwest School of Innovative Learning, because it deals with dealing with difficult students. And again, I'm sure that you've seen that in your day-to-day, you know, students that are just a handful. Well, in this particular case, this student was exactly that, just an absolute handful, difficult, cantankerous, not listening, that sort of thing. So the student, who is a 15-year-old, comes out of the school and is disruptive, but in the process of being disrupted is pretty much guided onto the bus by a teacher or some sort of administrator who gets the kid on the bus and basically says, you know, sit down, and pretty much, you're not my problem anymore, you're the driver's problem, and goes into the building. Okay. The student is on the bus, off the bus, on the bus, off the bus, while other students are loading. And the driver does her best to, you know, please, you know, get on the bus, sit down, that kind of stuff. Bottom line is the student will not get on the bus now. The student says, I'm going back to school, goes back to school, the doors are locked, bangs on the doors don't open, okay? So the dispatcher does the right thing. The driver calls the dispatcher and says, look, you know, Sally, this problem student, is outside of the school, won't get on the bus, I'm loaded and ready to go, what do you want me to do? They had a policy that said, call 911. The student comes back, okay, and says says, look, I'm gonna call 911 unless you get on the bus. The student says, the cops are gonna arrest me, I'm not sticking around, and runs.
Oh boy.
So, okay, what do you do? The dispatcher called 911 and the driver left with the remaining kids. Okay, so again, they had a policy, they followed it. Well, unfortunately, the student went to another location and was assaulted. Terrible thing, but not the school bus operator's fault. Now, the parents sued the school, sued the school bus operator, sued everybody. But what saved them in this scenario is they had a policy, they followed the policy, and they did everything that they could. You know, I can't physically grab the child and sit him in a seat, especially a 15-year-old. You know, this is not a 5 or 6 or 7-year-old. This is a, you know, practically an adult, you know. But in any case, what really saved them, and I think the takeaway for contractors is you've got to look at these kind of scenarios that are not that uncommon. I mean, you know, a difficult student that just won't listen to simple and fair direction. You've got to decide what is your company's policy for how to handle this, whether it's calling 911, calling the school superintendent, have it written down, make sure that it makes sense, and make sure your drivers are aware of it. The last case that I've got is a case out of Connecticut. This is a November of 2016 case, and this is another one that involves student discipline, student supervision. So here's the situation. It's, again, another middle school kid, and in this particular situation, the school bus arrives to the school, unloads the kids in the morning, and unknown to both the school and to the driver, this particular student gets off the bus every day, goes across the street to have a smoke, because you're not allowed to smoke on school property. So they go across the street. That kind of thing. Now, everybody knows the chaos that a morning middle school neighborhood is. So the evidence, the testimony revealed that the school bus driver had no idea that this kid did this every day. Okay. And the reason it's important is one day crossing the street to catch a smoke, kids hit by a car. So the parents, of course, say, well, it's the school's fault, it's the school bus driver's fault, school bus operator's fault, because they didn't maintain supervision of the student. Well, the reality is it went back to what's the reasonable expectation. If you unload 60 or 70 kids from a school bus, you can't keep eyeballs on 60 or 70 kids while you got the walkers that are coming in, the other buses that are unloading, the parents that are dropping off, the students themselves that are driving in. You got them to the curb safely. They disembarked, and they're expected to go to the school and go in. So in this particular case, both the school was not held liable and the driver operator was not held liable either, because they said that there was no reasonable expectation. It was clear that they didn't know that the student did this every day. And so they had no way of being expected to do something about it. Now, it was pretty clear in reading that had they known, like if the driver had testified, yeah, I see this happen every day, I think that there would have been an expectation, at least, that they would have reported it to the school and, some activity would have taken place. But the important part here was, the school was doing their job. Again, they don't know if the student walked from here to there. They just, are lucky to get the kids in the door before the bell rings. And the driver was the same. So, those are a handful of cases that have come from the cases that we pull from time to time. And like I said, they're a little bit from all over the place, but the theme is the same. And the point there is that you're doing good work, you're doing hard work. The better you document your procedures, the better your defense will be if something bad happens. So I ran down cases. Maggie, do we have any questions online?
Yes, we have one question regarding the red dyed fuel. So in regards to the red dyed fuel, what are your thoughts on special needs pre-K runs?
I think, and that's like the Head Start type stuff, Head Start, pre-K, that sort of stuff. I would, and again, I'm doing this answer off the top of my head, I would think that the Head Start type runs, the pre-K runs, are probably more consistent and more within scope and intent of school, meaning not college, right. From the standpoint of being what was intended when they had carve-outs. I think that after, and again, this is just kind of the feel for me, after graduation from high school, I think that not only from a taxation standpoint and things like that, but just in the rules and the laws that are applied to students and even the environment of education is different. It's more adult. Here, most of it comes out of the Department of Ed. Now, those Head Start programs really are usually a creation of the federal government, not necessarily a creation of the state government. They've got the Head Start programs and a few others, but again, it is a situation where I know I've helped a couple of contractors dealing with contracts where the question and issue was, who pays for the fuel, and if the school district pays for the fuel, are they, then fueling the contractor's bus so they don't have to pay the taxes. And that's another one that can be very, very fact-based. You know, do you pay for the fuel and then claim a credit? Does the school district pay for the fuel and you don't ever have to even, you know, pay for it?
Right.
Or school district pays for the fuel and they take it off of your monthly payment. There's so many variations of it. The answer, I would say, is that I would expect that you would be able to use a tax-free fuel in that environment, but I would recommend that you and I talk in a little more detail about your specific factual situation in order to have some certainty on that. Any other questions out there, Maggie?
No, that looks like that's it.
Okay. Why don't we open the phones in case anybody is not online and maybe they have a question they'd like to just speak out.
Okay, I'm unmuting everyone now.
While Maggie's unmuting, before we wrap up, just a couple reminders. When you log off from this, you should be getting an evaluation survey. We'd appreciate if you'd fill that out. Also, as we mentioned, we're recording this, so eventually this will be uploaded along with the PowerPoint presentation to the members-only section of the PSBA website. If you don't have a registration, your user ID and password, you're able to request one off the website or contact Maggie in the office, and we'll help get you set up for that. So sounds like we're unmuting.
Any questions out there?
This is her saying that she's willing to do whatever, so this should be a folder, but then they're all just follow paper with.
Okay.
Here's what we're gonna do.
Okay, and what happened? She ran.
Hello, just so you all know, you're off mute now.
And we took everybody off mute to see if there was any verbal questions that anybody had.
We just didn't want anyone talking about anything they may not want to have out there.
I did get one question come through.
Okay, what's that?
So as a rule of thumb, this contractor is under the assumption that transportation initiated and reimbursed by a Pennsylvania local education agency qualifies for the use of RED in the home to school transportation and activities run. Are you in agreement with this understanding?
In agreement with the understanding with all the qualifiers that I said over the last hour. So yes, I believe that you are within the interpretation of the rules applying to taxation of fuel, running tax-free fuel on that activity run that you described. Can I guarantee that you'll never ever get jammed up? No, I can't guarantee that, but I believe that you have a very, very good defense if a rogue enforcement officer, just like the rogue auditor that comes in and says, takes exceptions that are inappropriate. So my answer to you is yes, but be aware of the background and everything that we discussed here today. And if you want to talk again about your specific situation, by all means, call through and we'll chat it up. Okay, great. Well, it's 11 o'clock and I actually do have a conference call after this. So I sure appreciate everybody's participation.